Good afternoon. As Kyle said, my name is Veronica Vecchio, and I am the new incoming Employment Law Section Chair. And this afternoon, I'd like to introduce Laura B. Wolf of Spark Justice Law Center LLC, who'll be presenting on Colorado's Equal Pay for Equal Work Act and its amendments, which were passed in May of 2023. Ms. Wolf graduated from Harvard Law School in 2013 and has devoted her legal career to advocating for individuals suffering from abuses of their civil rights. Ms. Wolf serves on the board of the Lawyers Civil Rights Coalition and the Rocky Mountain Victim Law Center, advocating for victims of domestic violence and sexual assault. She's also a member of the Colorado Women's Bar Association's Public Policy Committee and actively worked to draft the Equal Pay for Equal Work Act. She has been the recipient of many awards, including the Gary McPherson Outstanding Young Lawyer of the Year Award in 2020. We are very grateful to have Ms. Wolf join us here today. Thank you.
Hi, everyone. Thank you so much, Veronica. I realize I don't think I have screen share. Oh, no, I do have screen share. Never mind. It's nice to meet you all. Clearly, I have not figured out how to use Zoom in the 3+ years since we've been using it. It's nice to meet you all. Feel free, obviously, if you want to turn your screens at any point, obviously feel free not to as you're eating lunch. I just finished my lunch. I might snack a little on the screen despite the recording. I talk a little quickly. I'm working on that. I'm from New Jersey originally, so I'm going to try to slow down a little, but I apologize in advance if I get a little fast. And feel free to jump in with questions anytime. You can throw them in the chat. You can also just unmute yourself and ask questions. As Veronica mentioned, excuse me, I'm also drinking a soda. I have a tendency to burp when I drink soda. But as Veronica mentioned, I did work on drafting the original Equal Pay for Equal Work Act. I also was very heavily involved in the amendments. They were signed into law last week. So apologies, I hadn't updated the bio to note that, but they did pass in May and were signed into law last week. So we'll go through all of that today. And again, feel free to jump in with anything. I'm going to share my screen at this point. I don't know if you guys all have copies of these slides or not. I'm happy for you to get them from Veronica once we finish. So just ask her, and I'm sure she'll be happy to send them to you. So is this working for everyone? If anyone has any issues, do you mind jumping in the chat? I don't typically end up sharing my screen a lot in Zooms. Okay, not seeing any chats on it. I'm going to assume everything's working okay. So just beginning with the, basically what we're trying to do right now is to give you like an Equal Pay for Equal Work Act update. So beginning kind of with the start, beginning with the beginning. The Equal Pay for Equal Work Act went into effect initially in January of 2021, and the entire purpose of the bill was to close the wage gap that remains with the Equal Pay Act from 1963. By the way, these slides will have a lot of content on them. I know some speakers who don't love doing that because folks end up just reading the slides. I'm fine if you prefer to read the slides versus listen to me. But I have a lot of content on there because I want you to understand everything that the bill does, and it's quite complex. But essentially, as you all know, we've had an Equal Pay Act federally since 1963. Shockingly, women are still not being paid equally to men, especially women of color. And so clearly it's not working. And that's why we worked on getting the Equal Pay for Equal Work Act passed in 2021. It had been an effort for many, many years before that. And before my involvement, I was involved for about 2 years of drafting before it was passed. And then it was passed in 2019, did not go into effect until 2021. So I've been working on it since about 2017. The primary differences between the Equal Pay Act and the Equal Pay for Equal Work Act is that, one, we include sex plus discrimination. So as I mentioned, women of color, a lot of times you have, these moments where an employer can say, well, look, a white woman is making XYZ amount of money, therefore there's no pay discrepancy. And so our bill has sex plus. That includes not just race, but things like disability, age, other protected statuses. Second big difference is that the Equal Pay for Equal Work Act applies to substantially similar work, so not just equal work. The way the Equal Pay Act has been analyzed and interpreted has really limited the ability for women or for men who feel that they are being paid differently based on their sex to really raise that issue if they're not performing equal work. So we require substantially similar work in Colorado. And then finally, we got rid of the catch-all that I think was the biggest detriment to closing the wage gap. That's a catch-all in the Equal Pay for Equal Work, excuse me, in the Equal Pay Act, the federal one, that basically says a differential based on any factor other than sex. And so that all that means is an employer can point to literally anything besides sex and say, this is the basis, and we win. The problem with that is that, as we see, that did not cause the wage gap to close. And so that's why that catch-all was a really big part of this bill, and getting the bill passed with getting that catch-all removed. So what are the bases that you can pay people differently who are of different sexes here in Colorado? So you can pay people differently based on a seniority system, meaning, again, you have to have a system in place, not just, hey, this person's been here longer. Have a system. Merit system, very similar, have an actual system in place. A system, shocking, this word keeps getting brought up, that measures earnings by quantity or quality of production. So for example, sales commissions, things like that, where you have a quantity or quality of the production or of the sale. Geographic location where the work is actually performed. So you can imagine paying someone more money to work in San Francisco than you would in Kansas City, Kansas, just based on the cost of living. Education, training, or experience to the extent they're reasonably related to the work in question. So for example, I do not need a bachelor's degree probably to go and work at Abercrombie & Fitch on the floor and fold t-shirts. And so you should not be paying me more money because I have a bachelor's degree or a JD doing that work. But if the education or the training or experience is related to the work, then yes, absolutely, that person can be paid more. And then travel, if it's a regular and necessary condition of work. So I give this example a lot. I've had friends who worked in big law and who would travel literally to other countries for weeks or even honestly, sometimes days at a time to do doc review in other countries, which sounds terrible to me. I would rather travel for fun. And so this is an example of, hey, if you're willing to do this travel that honestly, my friends did not enjoy sitting on these planes for long flights, even in business class, we will pay you more because we understand that people don't really want to fly to other countries to sit in conference rooms and look at documents. So that's an example I give. Finally, employers have to show that the factors were relied on were applied reasonably, that they account for the entire wage differential, and that prior wage rate history was not relied on to justify a discrepancy. The big one there is that, as we know, oftentimes when we apply for jobs, people get asked questions like, what is your current rate of pay? When an employer is considering what to pay that person, that is no longer allowed under Colorado law, has not been since 2021. And we do not want employers to rely on previous wage history because that sort of compounds the problem. You should essentially, if you're an employer, be paying people based on the value of the work they bring, not based on how low of a pay or how high of a pay they were able to receive in a previous position. You should be doing it based on the work. There's no need to show intentional discrimination. This is not like a wage discrimination law. People use those terms far too interchangeably, even myself sometimes. This is just strict liability. So if there's a pay differential where two employees are working substantially similar jobs, different sexes, and paid different amounts, the person who's being paid less can bring a claim. And that can be a man or a woman. It does not have to be a woman who brings a claim. I'll go to prohibited conduct and then I'll ask if there's any questions. So prohibited conduct related to the wage rate, as I just mentioned, is you cannot ask for someone's history of their wage rate, meaning like their salary history, when you were interviewing them. You also can't discriminate or retaliate against someone for failing to disclose that history. You can't discriminate, retaliate, or interfere with an employee or any other person. I want to be clear how broad this is. Any person, even if they don't work for you, for inquiring about, disclosing, or discussing wage rates. So we have very, very broad right to discuss wage rates in the workplace. You also can't interfere with an employee's ability to discuss their own wage rate in addition to others. And you cannot discriminate or retaliate against anyone invoking their rights under the subsection. So very, very clear right to talk about your wages in the workplace and make sure you're being paid equally. And also very clear right to not have a prospective employer ask you about your previous wages so that they don't rely on that when they set your wage. And just to know, I use this term wage rate a lot instead of salary or hourly compensation. And because wage rate is all the compensation and benefits. So if you hire a man and a woman to do the same job, but you tell the man, hey, you're going to get 6 weeks of paid vacation and the woman gets 2 weeks, that actually impacts the wage rate. That's 4 lost weeks of paid vacation they would have gotten. So again, benefits also have to match. Before I go on, any questions anyone wants to raise before I go to the next slide? And if I'm talking too quickly, I know I probably am. Just tell me. Okay. think I'm not seeing any questions. I'm not sure with the full share screen, the full screen. So someone speak up if I'm missing a question. Okay. Next, talking about enforcement. So there are both private and public rights of enforcement under this bill, meaning you can both privately bring a claim for certain violations of the bill, and you can also report some of the violations to CDLE, the Colorado Department of Labor and Employment. So beginning first with private enforcement, so bringing cause of action, you can bring it. We have changed this law. I want to be really clear. The way that it's worked under the Equal Pay Act, and this came about with the Lilly Ledbetter, even the Lilly Ledbetter Fair Pay Act has this as well, is that you have to sue within 2 years of every payment, every like pay date that you receive reduced wages, meaning that you're sort of on this like ongoing ticking clock. It's almost like a little time bomb. And that means if you quit your job or you're fired or you leave for some reason, you have to file your lawsuit within 2 weeks if you want to capture all the wages you lost up to the maximum. That is not how anything else works in the law, as you all probably know, besides wages. If you get hit by a car and you want to bring a lawsuit, you have you have 2 years to bring your lawsuit, and based on the date you're hit. And so in this case, what we did is we changed the law to match that. So basically you have 2 years from the date of the last unlawful pay discrimination, or not discrimination, pay disparity. You have 2 years from that date, and then you can look back for 3 years of unpaid wages, meaning if I was let go, well, I work for myself, but if I fire myself today on, what day are we on? June 13th, 2023, I have until June 13th, 2025 to file my lawsuit. And then I can look back for 3 years from June of 2020 on, okay? The point of that is that people do not want to rush to file lawsuits. Employers don't want lawsuits rushed and filed against them, but also we don't want to change the statute of limitations the way we have for wages in the past. We want it to be that people are able to seek their wages in the normal 2-year amount of time that they could have. Starting in January 1st, 2024, based on the new law or the amendments that were just passed to the law last week and signed into law last week, now you can look for 6 years of back pay. So now I would be able to look all the way back, not from June 2020, but June 2017. So keep that in mind. The reason for that is most people do not stay in jobs for 6 years. Most people leave jobs sooner, and we want to make sure that people who are loyal and hardworking employees to an employer are not basically the ones who suffer the most from any sort of long-standing pay disparity. Also beginning on January 1st, 2024, CDLE will have enforcement authority. What that means is right now, CDLE does not have the authority to investigate and to find, basically to adjudicate claims of pay disparity based on sex. You always had to do it through a civil lawsuit. Now that has changed. Now CDLE can do it. It's not, starting in January. There will be no administrative exhaustion requirement. So it's not that someone has to go through CDLE or, before they can go to court. It is just an option. It's typically going to be used, I'd say, by people who don't have attorneys or people who have smaller wage claims. Also, CDLE will be able to start mediating complaints, so trying to get to a resolution outside of a pure adjudication beginning July 1st, 2024. Any questions on any of this before I move? And again, you can ask questions at the end too, but if you do, I can't really see the chat easily. So if you do have a question, it's easier to unmute and just jump in with a question, okay? Liability regarding the pay differential is probably a big question you all have, is what will an employer be found liable for if there is a pay disparity? And so an employer found liable for a pay differential will be liable for both the differential and an equal amount of liquidated damages. So, and these are automatic under the law. It's just like the FLSA, it's automatic, except that the employer can move the court not to award them if they can show that the violation was made in good faith. They had reasonable grounds for believing it had not violated the section. So for this one, oh, I do see a chat. It did pop down. Let me ask. Are employment claims waivable in a separation agreement? That's a great question. So I'll pause for a second. The question was asked is, are these claims for equal pay waivable in a separation agreement? So as you all know, for example, you can't waive your right to wages, like straight wages for your time worked in a separation agreement. So if someone worked for 2 weeks and they get paid at the end of their employment and they sign a separation agreement, you still have to pay them. I don't think this has been really decided whether this would be waivable. I think it's going to match what the Equal Pay Act is. And I think it would be hard to argue that these are not waivable personally. I don't know how that's going to develop, but I do think there's this little bit of a difference between straight wages owed for hours worked compared to a claim for disparate pay. But since this does mirror the FLSA, I'm not positive. And if the Equal Pay Act is similar, and I haven't researched this myself, if the Equal Pay Act's claims cannot be waived, then I would say these ones cannot be waived. But that's a great question. I think it's going to be battled out in the courts. Typically, I do resolve Equal Pay Act cases, and I consider when I resolve them, I mean, obviously I'm resolving them for my client, but I consider them obviously waived as a result of that resolution. I think it's a little bit safer to say that straight wages that you've already been agreed upon to be paid are not waivable. So keep in mind, liquidated damages would be automatic if someone wins their claim unless the employer shows it was good faith. I think good faith is going to be easier to show in an equal pay context than in the FLSA context. So this language mirrors the FLSA, which basically says if you just don't pay someone their wages, let's say, and then the person has to sue under the FLSA because you didn't pay them their minimum wage because you didn't pay them any wage, or let's say you didn't pay them overtime, they have this right to liquidated damages. It's very hard for an employer to show that that was a good faith violation. Obviously, if you didn't pay the wage, you didn't pay it. I think an example where it could be good faith is like a misclassification case where someone was misclassified as being exempt from the FLSA, but they weren't. In this case, I think unless you have people doing the exact same job, and I've actually had a case like this where two people were literally doing the same job. They were working different shifts, covering the exact same job, exact same title. They were meant to never overlap for that reason, who are paid substantially different amounts of money on an hourly basis. I think that's one of the few cases where an employer would not be able to show good faith. However, I think in most cases, an employer can say, I had a good faith belief. Let me explain why. So I think this will be a little bit easier for employers, but I would say to be protected as an employer, you want to make sure if you have pay differentials, you're looking at that list and you're kind of having some type of paper trail or explanation in writing as to the reason for pay differentials. But yes, I do think it'll be easier to show good faith in this context. The other thing is, of course, there's other forms of equitable and legal relief, like a reinstatement. So we're seeing courts more and more shift towards saying, hey, equitable relief includes reinstatement. So in this case, if you had someone who was fired for raising concerns about their wages or speaking up for another employee's wages and wage differentials, and they get fired for that reason, I think they could sue and actually be reinstated. And then finally, this has a fee shift in it, just like other civil rights statutes. So keep in mind that there's an attorney fee shift if the case proceeds litigation and it's successful. Going into posting requirements for any of you who are doing this work for employers or like myself have your own business, I'm sure the posting requirements have been a bit of a headache. We did try to address a lot of that in the amended bill that was just signed into law that will go into effect in January. But I just want to kind of walk through posting requirements. The biggest thing I want to say about posting requirements for everyone who's really concerned is that these cannot be sued upon in a private lawsuit. So the private lawsuits are related solely to like pay differentials. A person cannot sue because an employer did not post something properly. The most they can do is make a complaint to CDLE. And obviously CDLE is able at that point to issue a fine, but in my experience, I've seen only CDLE give out first notices of warnings prior to ever issuing any sort of fine, because the whole goal is to get to compliance. So I also want to be clear that while I know some of these requirements are onerous, I don't think they're as scary as some people think they might be. The goal is to get to your best effort. It's not to have, dozens of lawsuits filed against an employer for failing to post properly. So there's two types of posting requirements I want to talk about. There's internal postings related to essentially job opportunities. It's going to be changed slightly from promotions. And then there's external postings for jobs. So starting with the first, you are not, or actually, let me start with the second, which is external postings. You are not required to post for a job if you have a candidate in mind that you're going to hire. You're not required to externally post on something like Indeed or like the CBA's, notice boards or job boards. You don't have to do that. And so I'll give the example of my own law firm. When I hired my first attorney, I did not know who I was going to hire. I posted a job. It was a few days before the law went into effect. I clearly worked on writing the law, so I complied with it regardless. And I got great candidates and I interviewed them and I hired from that pool. The second person I hired was someone I knew and who I went to law school with and who I knew I wanted to hire. And so there was no post that went out for that person's position. I did interview. I had my current attorney interview with them just to make sure it was a good fit, but I didn't post it. Okay. You're not required to do that. And under the current iteration of the law, you're only required internally to post promotions to staff members so that staff members know if there's a promotion so they can raise their hand. And we're going to talk about the shift in that in a moment, just so you have an understanding of that. If you decide to make a job posting externally for a position on your team, you have to include in that job posting the hourly or salary compensation that you're going to be paying, or a good faith range if there's a range, and then a general description of benefits you will be providing. So, for example, if your role is going to be between $60,000 and $70,000 a year based on experience, put that range in your posting. If you're going to offer a 401k, health benefits, vacation pay, bonus opportunities, a general description of those benefits is all that's needed, nothing super specific. Make sure that's in every posting. And yes, you can go outside of the range for anyone who's wondering, like, let's say you got a stellar candidate and they have way more experience than you were looking for. And so you put 60 to 70K, but you think they need 80K to get the job done. Great. If you want to make the offer of 80K because they were really outside of your range of what you were expecting, go for it. Just as long as it's a good faith range of what you plan to be paying for the position. With any questions on that piece before I get into promotions, just want to be clear about what external postings require and the fact that you do not have to externally post for a job in order to hire for it. Okay, no questions on that. Posting requirements for promotions is a bit different, and we have cleaned this up for this year, so I won't get too into the weeds of current law because it's about to shift in about 6 months. But currently, an employer was required or is required to make reasonable efforts to announce, post, or otherwise make known opportunities for promotion to all current employees on the same calendar day and prior to making a promotion decision. And the reason for this, the reason we were looking for this was because there's so many times that we see people in vulnerable groups, in marginalized groups, women especially, people of color especially, non-binary individuals who are passed over for promotion. And so we wanted people to be able to raise their hand and say, I'm really interested in that job. And sometimes they're passed over for promotion, if not most of the time, because they're not being seen in the workplace, not intentionally. And so we wanted an ability for those people to know about an opportunity, raise their hand, and for an employer to say, oh, I hadn't thought of you for that position, but that makes a lot of sense. I think you'd be great in that role. This was not really working well in practice, and we got some feedback from folks who were trying to implement it who are having some problems with that. So we're going to talk through in a moment the new requirements that are going to start in 2024 where we made these changes. And there were always, and there continue to be exceptions, by the way, for the promotional posting requirement. To get more information on those exceptions, I really would look at the informationals, but this CCR, the Colorado regulation on this, is really specific about the needs for confidentiality, an automatic promotion after a trial period, and temporary and interim hires. So there are exceptions to this rule. So beginning on January 1st, 2024, this was a lot of work working with the business community and trying to get these changes implemented. So this was us collaborating for quite some time to make these efforts possible. Now, instead of calling something a promotion, because there was a lot of confusion about what that meant, now we are just requiring that job opportunities within a workplace need to be posted internally, with limited exceptions for certain types of remote workers. So you can look at the law for all those very limited exceptions for certain remote employers. So if you're based here in Colorado, you have to comply even if it's for a remote job. This is for remote employers with only a set number of remote workers in Colorado. Job opportunities, just to define it, means current or anticipated vacancies for which an employer is considering candidate or candidates. It does not include career development or progression. I want to explain that because a lot of people were concerned that someone is like ready for that next step in their career and it's part of their normal career development, but that they had to post the position. It's not considered part of a promotion if it's part of their normal career development. So if they're going to go from admin 1 to admin 2 in 1 year, so long as they stay in good standing, you do not need to post that. And that's actually typically career progression. Career development, so let me rephrase the term, that's more career progression. Career development is things like you need to reframe or restructure what someone's position is based on the work they're doing. So I always give this example from my first job. The first job I ever had outside of law or outside of undergrad before law school was working at a hedge fund, and I was hired to be I was hired to be a receptionist. It actually said that in my paperwork. I was like never a receptionist. I think by day 2 or 3, they realized I could do more than that. And I ended up doing back office operations and compliance. So they, I think, changed my title at some point, and I didn't get more pay, but they did change my title at some point to reflect what I actually did. That would be something like career development. And let's say they increase my pay commensurate with the fact I was doing more work, that would also be career development. And so one of the things we saw is that people were getting nervous about restructuring someone's role to reflect the work they were doing based on our old law or the current law. And so that's what we have shifted, is that if someone is just going through a career development, naturally, you don't need a post for that position because you're not really going to hire for it. You're just explaining or expressing that this person is already performing this work. So I'm happy to get into all the specifics of that if anyone has questions. And then career progression is more like the progression track I just described before. In addition to that, all job postings, both internal and external, so the ones you provide internally, and then should you choose to post it externally, do have to include the hourly or salary or hourly compensation that we described, the general description of benefits, and the date the application window is anticipated to close. It can obviously close earlier, it can obviously extend longer, but the anticipation date for the closure. Any questions on any of this? I'm getting sick of my own voice. So if someone wants to chime in, you're welcome to chime in and offer a question. This is a little bit complicated, but again, it's meant to actually ease up on the requirements for the promotional postings. We also have notice requirements. So this should be simple and obvious, let me be clear, but I think a lot of people were shocked by this, but to me, this seems really obvious that if you hire someone to work on a team, you should let your team know that you've hired them. So within 30 days now, beginning on January 1st, 2024, if you select a candidate to fill some type of a job opportunity, so basically to fill a job, you must disclose, an employer must disclose the following. To a minimum, you can disclose it to everyone in your company if you want, but at a minimum, you have to disclose this to the employees with whom you intend, the employer intends, the selected candidate will work with regularly. So the team of people they work with. So you can imagine an employer the size of Google does not feel the need to post to the entire workforce internationally who they just hired, but probably my own team of 3 employees, I'm probably going to tell everyone because 1, they probably will work with everyone, but 2, we're a small team. So that's why we put that language in, at a minimum, the people they're expected to work with regularly. You have to disclose the name of the candidate, so of the person who is selected. You have to disclose their former job title if this is a promotion or an internal hire. You have to disclose their new job title, and you have to disclose information on how interested employees can demonstrate interest of similar opportunities in the future. Okay, so that way people can raise their hands and say, you know, if this position or something similar comes up in the future, I'd really love to know about it. This does not create any burden on the employer to then notify them. This is just a way so that people can raise their hands, start kind of having that discussion. There is no additional requirement that employer add them to a list, contact them with certain opportunities, nothing like that. So don't, feel like you have to create a list and start doing that if you're, representing employers. And then there are exceptions in the law for privacy rights and health and safety. So for example, a crime victim who's a victim of stalking or harassment says to their employer, hey, I really need you to not announce broadly my name and information because I worry this company is really large. This could get back to my ex. Great. We don't need to do that. Obviously, the people on that person's team they're going to know who this person is. But you just let your employer know, hey, this is a health and safety issue or a privacy issue. And then there are additional notice requirements just to be aware of for career progression. I want to be clear about. So always look in the law for those additional requirements of notice. Any questions about any of this?
Laura, is an email sufficient for providing that notice to the team?
Absolutely. Great question. Yes, any type of notice. So an email is like the way I would go about it. Or if you have an intranet, if you're a larger employer with an intranet. But I think an email, especially when it's to the team, is what happens naturally because people just say, hey, this is good. I mean, obviously in the white collar workforce, I don't want to speak for other workforces, but here, that's typically what happens. Technically, there's no other form of notice. Like if you work in a plant, like I've represented employees who work in plants, and they say, this is your new line supervisor, that's technically notice as well, as long as all the employees are there, or you can let them know, if some of the employees are absent that day on another day, as long as it happens within 30 days, and some mechanism for notice.
I have one more question, which I think that a lot of us thought we understood the statute, and then the rules came out and we were all like, oh, yeah. So do you anticipate there being another round of rules that we should be looking out for that might change this lesson?
I anticipate there will be rules. However, I think that they'll be clear now because I think a huge reason we needed the rules on promotions last time was that the law was pretty vague and the rules had all these exceptions and the rules had these definitions for what promotion was. And we had all this thing about how it could be like, honestly, things that now we're calling career development that are excluded from that notice requirement, like things like a change just to title, even if it's not to pay. I can't remember, there was something where if it's even a change to one thing, but not another, it almost always counted as a promotion. And that became the big issue. And that's where employers said, this really isn't workable. Let me explain why. And our goal was saying, well, we don't want to prevent someone who, let's say, is performing really great work from getting that additional pay or that title by creating this like difficulty in the process. And so I think there will be rules, but I think a lot of those are just going to pull back what we currently have and only clarify what needs to be clarified. But yeah, I don't know for certain. I've like not spoken to CDLE about it. But the current rules will certainly not be relevant to the promotional piece once this goes into effect. And then posting exceptions that currently exist. For example, under the promotions, you don't need to post to employees entirely outside of Colorado for a job that can only be performed in Colorado. For example, if you run a Pizza Hut franchise and Pizza Hut is hiring delivery drivers in San Francisco, you do not need to post for that here in Colorado. And then compensation, the range of compensation, again, doesn't apply to jobs to be performed entirely outside of Colorado or for postings entirely outside the state. So an example of that would be like a billboard saying Domino's is hiring here in California, you know, on the interstate. You don't need to then post a salary range. It's clearly not for Colorado employees. And then all of you have seen the articles like remote workers or Coloradans need not apply to these remote jobs. That does not exclude any employer from having to comply. I think it's a very silly idea of how to get around this law and probably not very popular, but it will not undo the obligation to actually post the pay range, even if you choose not to hire people from Colorado. And this was just, I screenshotted this during a CDLE like public, you know, sort of informational, I can't remember what they called it, but sort of explaining the rules. I screenshot this and have stolen it as my own. I did not make this, but this was a nice chart if anyone wants to see a chart about when you have to announce promotional opportunity, or excuse me, announce job postings and include the pay range in it. Obviously, we talked about enforcement a little bit. So CDLE can promulgate rules. I anticipate they probably will with the new the changes to the law. CDLE, by the way, like they were aware of all the drafting changes and whatnot going on too. So it's not like I hope that I would be surprised, and I hope not that they come in and try to sort of shift some of the language. I don't think that they will, because the language is pretty clear in the new law. And I just think the last one was pretty vague. Second thing to know is if you're aggrieved or you just see a violation of the rule, even if you're not aggrieved, you can report it within 1 year. So you can't report it after a year. So keep that in mind. CDLE can enforce their laws by requiring fines of no less than $500 and no more than $10,000. They still interpreted that to be able to provide warnings. So don't worry, like the first violations are not getting fined $500. And then I said, we have the new law line for enforcement of the actual pay differential, so adjudication. And again, there's no private cause of action for things like failing to have an adequate job posting or post at all, or internally post a promotion. All you can do is complain to CDLE, which is fine, but I want employers to not get so nervous that they're going to get lawsuits over this. Biggest differences between the EPA and the Equal Pay for Equal Work Act is that the Colorado law is much more restrictive on the basis for the pay differential. It also makes the employer explain the basis for the pay differential, which kind of shifts who has to make the explanation. So back in the day, I think employees really had more of the burden of explaining it and saying like, here's some reason, here's some reason. I think now employers are the ones who have to say, you know I pay these two people differently, and I have to explain why I'm paying them differently. Versus it always being on the employee to say it's definitely based on sex. We also are aiming this at wage rate history. So we don't want salary history to come into these decisions about what you're going to pay someone. The way I tell people this is I actually think this is a best practice for employers when I am putting together my for the year and deciding who to hire. And my firm has been around for 3 years and I already have 3 full-time attorneys, which was not something I necessarily anticipated when I started my firm. I certainly don't sit down and plan my budget by saying, I don't know, whatever this person used to make, I might offer them that amount of money. If I did that, I would be not doing a great job as a business owner. So when I sit down and I budget how much I can pay for a role, I budget it based on my expenses, the amount of money I have, and the fact of what I think the value of the position is. And that's what I think a best practice is for any employer to do. It's a bit broader than the Equal Pay Act in terms of the similar work comparison. So equal pay versus substantially similar work. And we are also focused on promotional and hiring transparency, as you know. We have far more technical requirements in the Equal Pay Act in terms of what the regulatory requirements are for employers. And then it allows that sex plus claim, as I mentioned earlier. And then we will have some time for Q&A, because I know I didn't realize I'd get through this quickly, but so we can chat all about things. But it is possible to violate the Equal Pay for Equal Work Act without violating the EPA, obviously. That was the whole point of it, was to make it stronger than the EPA. Whereas I think if you're looking at this in like a sort of a diagram model, like what is a rectangle versus what is a square, the square is the EPA and the Equal Pay for Equal Work Act is rectangle. So the EPA will always be a rectangle. If you violate the EPA, you have violated the Equal Pay for Equal Work Act, not vice versa. Therefore, if you're a Colorado-based employer or you have employees in the state of Colorado, or you're advising those folks, you should always focus on compliance with the Equal Pay for Equal Work Act, is my view. There's far more risk under that statute, and I just can't see, and someone tell me if I'm wrong, I can't see a situation where you violate the EPA, not the Equal Pay for Equal Work Act. Finally, there are things for employers to consider is that you should put processes in place to assess job postings and promotional postings or job opportunity postings for compliance. So some type of process to check that they're meeting like the rules and the regulations. You can consider things like a compensation audit, where you can get an external company to come in and audit whether people are being paid equitably or equally under the Equal Pay for Equal Work Act. That will go to that good faith defense that we were talking about earlier, saying, hey, look, we have this audit. We thought we were doing everything on the up and up. You should have more formalized job descriptions if you're a larger company, and qualifications. So again, because you want to make sure these things match, you might want to have more formalized descriptions. At the end of the day, though, what someone is actually doing in their job is what's going to matter more than their job description. So I have a case like that right now where the job descriptions are totally different for my client and a male employee, but the work they were actually performing was almost identical. And that's the real issue in the case, is that my client was paid significantly less to do pretty identical work. Update record keeping procedures for compensation factors. So you want to obviously have record keeping to show, again, good faith compliance, and that you're looking at these factors as you're considering these your compensation decisions. And then create some type of employee evaluation system, but also assess it. So if like the system is incredibly subjective, you probably want to add more objective metrics. Or if you're using different systems across different departments, that might be okay, but not within a department. So again, because you want to make sure that people are being assessed who have comparators within like the same group they're in. Possibly with beyond different departments could also be a problem if the different departments are just focused on different regions, let's say in the US, but they're otherwise doing the same work. Then you want those departments matching in the terms of their merit assessments, performance evaluations. So just keeping an eye to all of those pieces. Any question? I know that's like the fastest I think I've ever gone through this. So let me pause and ask. I clearly talk very quickly. That should not discount the 50 minutes, because if I were talking at a normal pace, we'd be well beyond an hour. But any questions that folks might have about anything that we just went through, or anything we haven't talked about that you might have a question on? I wish I had like a ringer in the group. I will say I've gotten about 12 texts since we started this. So, you know, they all have questions. They don't know what I'm talking about, but any questions or thoughts? You can also tell me that you hate the bill, and that's okay. I won't be offended. Or if you love it, I'll love you too. Are there any nuances? So this is in the chat. Are there any nuances to the applicability of the act in the public sector education? Great question. So there are some nuances in the public sector. Great point. So first one is CDLE, because it's a state agency, does not have the discretion or authority to investigate and adjudicate claims against the state government. So if you have a claim, for example, against the state of Colorado, let's say you work for University of, let's say you work for CU, and you think you're being paid inequitably, you cannot bring a complaint through CDLE even when they have that adjudication ability starting in January. You will have to file that as a lawsuit because you can imagine the conflict having a state agency determine that. We thought through a number of conflicts with that made sense that we had to exclude that. As far as education, no, there's no other like discrepancies either in lower or higher education or in municipalities either. We did talk a lot. I know when this bill was first being drafted back in 2019, well, it was prior to 2019, but it got passed in 2019 originally. And during those years of working together, we did work a lot with CU in particular to talk about sort of how they're meant to hire professors in different fields and professions that go for obviously different rates. With respect to public sector, the biggest reason I think that we would, to say that we made the changes on the promotional piece of it was that the public sector was the ones coming to us saying, hey, we have problems with the promotional piece because they have very transparent hiring and because they can't just make an announcement without really opening a competitive process for hiring. They were having a lot of problems with sort of reclassifying an employee based on the work they were actually doing. And they were basically in a position of not being able to adequately compensate or change the title of an employee performing additional work because of the promotional notice opportunity or promotional notice requirements. And so they were the ones who came and said, hey, we would really love to see some changes. That was a really collaborative process. I learned a lot from working with them. And, I can't speak to their position on the end of the bill, but we worked really well together on getting these pieces passed. So there's no change to how they're treated so much as they had a really big say in these amendments to the bill. Other questions or thoughts? Thank you, Packard and Durkee, whoever is from, and I apologize for enunciating your firm name. I'm sure I just did, but thanks for jumping in with those questions. I see Deepak on the call. I want to call you out, Deepak, because I know you. Do you have a question for me? And if not, no worries. I don't need to keep you guys to the whole hour. I just want to make sure you get your CLE credits. You're also welcome to tell me complaints.
Hey, Laura, it's Kyle. So if no
one
one
of my
has
interns who's here has a question, can I have her ask it and I'll just say it?
Oh, absolutely. And I was gonna just verify, Laura, really quick. You're able to send me the slide so I can send that out to everyone after the fact? Yep.
Absolutely.
So I got that question for me, but that's
Perfect.
now questions for you. Go ahead.
You want to say it loudly?
Yeah, wondering if, I'm trying to phrase it correctly, if there's a man and then a transgender man, how does transgender or trans people play into the bill, and how could they raise the claim depending on?
Yeah, so the question is basically, how does this bill impact folks who are trans? So the bill shouldn't change basically anything based on, like it should apply as long as you can show a gender-based discrepancy, which includes being transgender. So as long as someone can say, look, I'm being paid differently than a binary man or a binary woman is being paid for substantially similar work, I believe that you should be able to bring that claim. It wasn't as considered back when we were drafting this initially, like shows how much things have changed in literally the last 6 years, that it wasn't as considered when it was being drafted in 2017, 2018, as I think it would be now. But I read the law to apply based on gender. It does not need to be a binary gender. Great question. Well, I see no other questions, though Deepak, I'm disappointed in you for not asking one. But Deepak was the person who connected me to do this presentation. That's why I'm calling him out. But it was nice getting to see all your black boxes and a couple of photos on them. And I hope that this was a helpful presentation. And I'm welcome anyone, you're always welcome to reach out to me. I don't do employer side advisement. Thanks, Deepak. I don't do employer side advisement. The last couple of slides I kind of stole from a co-presenter of mine that we recently co-present this bill with. So I stole from him. If anyone needs any names, many of you I think are employer side, but if you need any names of folks, if you're not, just let me know.
Well, again, thank you so much, Laura, for presenting. And if anyone has any questions, you can always route them to me and I'll make sure Laura gets them. And I'll send out that CLE form and the slides as soon as I receive them. And yeah, thank you again for presenting. A lot of thank yous are coming in, Laura. So again, thank you for presenting. This is great. This will be a great resource for people to follow up on if they do have any questions or just need a refresher. So
Perfect.
really appreciate it. And thank you, Deepak, for introducing us.
Have a good day, everyone. I appreciate you.
Thanks, everyone. Bye.
Bye.